All right. Good morning, everyone, and thank you and welcome to our Think New York webinar series. This is the fourth installment of the Think New York webinar series, and we're trying to bring these to you on a monthly basis. They're hosted by the Empire Center, and as the Director of Public Affairs, my name's Kyle Davis. I'm very glad that you could join us this morning. Before we begin, I really want to encourage active participation by utilizing the Q&A feature. Our Director of Research at the end of the presentation will make sure to go over the questions that get dropped in the chat. So make sure as we go along, you're putting those questions in there so Ken can engage at the end. At the Empire Center, our mission revolves around promoting transparency, accountability, and fiscal responsibility in government. Our research encompasses various policy areas, including tax and budget, healthcare, energy, education, and labor that you will all be learning about today. We're excited to delve into the crucial aspects of New York's governance, so specifically the Taylor Law, so our state's public sector collective bargaining legislation. This legislation significantly influences just about every level of government. And so we're glad to see a lot of folks on from both state and local government today. During this webinar, you will also get an in-depth explanation of some of the historical backgrounds that go into making this law and how we have what we have today. So leading today's discussion is my colleague, Ken Gerard, and he is the Director of Research at the Empire Center. His background really encompasses a lot of expertise in labor policy, so we're very glad to have his perspective today. Additionally, slides will be made available today, and we'll make sure that the recording gets up on YouTube as well. So all attendees of this event can have access to that. And like I said, make sure you're utilizing the Q&A function. Otherwise, I will turn it over to you, Ken. Thank you for being with us this morning.
Thank you for that kind introduction, Kyle. I appreciate it. So, good morning. Thank you for joining us. To give a little background, part of what got the Empire Center so interested in the Taylor Law in the early days of our work on New York public policy was the fact that government is expensive in New York. And the biggest part of that expense in a lot of instances is personnel costs. And there's no law in the state that has as big an impact on personnel costs as the Taylor Law. So given our interest in tax policy and the state's economic competitiveness, it's necessary to study and understand the Taylor Law. What you see here is the cover from Taylor Made. That was a really groundbreaking report written by our founder, E.J. McMahon, and Terry O'Neill, a terrific labor lawyer from Long Island, doing probably the first ever critical analysis from a taxpayer perspective of the Taylor Law. They did this report in 2007. They updated it in 2018. A lot of the history that I'm going to mention today comes out of that report. It's a really great read. It was one of my first reads, even before I came to the Empire Center, one of the first Empire Center reports I ever saw. It was really eye-opening. So I commend it to your attention. As an overview for today, we're going to go through a little bit of the background and history of the Taylor Law. Then we'll talk about the mechanics of the Taylor Law. We'll talk about the Triborough Amendment, which is probably the most important part for a lot of folks of the Taylor Law in terms of what separates the Taylor Law from other state collective bargaining laws. And then we'll talk about some of the current issues. Obviously, we can't talk about all of them. The Taylor Law touches every part of public sector employment in New York, but we can talk about some of the particular hotspots that we've been paying extra attention to at the Empire Center recently. And then we'll open things up for Q&A, and I'll be happy to dive into any particular area we can. Also, before I begin, I want to acknowledge I'm not a lawyer, number one, so I can't give legal advice on this call. However, also in not being a lawyer, I want to thank the number of real labor lawyers who helped me through the years with my understanding of the Taylor Law. Terry O'Neill, for one, Jim Romer, Elaine Gold, former PERB chairman Mike Cuevas, Carly Bolaños. All five of them have been great resources over the years in helping folks at the Empire Center understand the Taylor Law and talk about just the real world implications of the law. Because it's one thing to read that section of the civil service law. It's another thing to understand how it's affecting the nuts and bolts of government on a daily basis. And those folks have been terrifically helpful. So, just to give some background before we get into the law itself, I want to draw a distinction here between unions and unionizing. One of the biggest misconceptions around the Taylor Law is that before it passed, somehow we didn't have unions in New York, or people couldn't belong to unions. That wasn't the case. The biggest union in state government, CSEA, was founded in the 1920s as a voluntary association. For police and fire departments, the groups that became their unions date back to the 1800s in some cases. So these voluntary associations had been around for a very long time. The difference between being in a union and unionizing, if I could really summarize it, would be when you unionize, you create a legally binding relationship between the union and the employer. Now, for that to happen, there has to be some kind of legal framework in place, and that framework is going to cover things like defining when there is an obligation to negotiate, defining which employees are covered, figuring out how to decide which employees are covered, that is to say, how elections are conducted or how the unions are picked, then deciding what subjects can and cannot be covered by the union contracts, and then ultimately how to resolve disputes when they inevitably come about. So these are all things that need to be in the law. And I'll draw another distinction. The reason the Taylor Law exists is because public employees are not covered by the law that covers private sector employees. So they bargain under something called the National Labor Relations Act. Some people call it the Wagner Act from when it was enacted in the 1930s. But public employees aren't covered there. So that means the states are left to decide on their own how to handle the relations between unions and public employers. And the states make a lot of different decisions about this. In some states, there's an actual legal prohibition, sometimes in the Constitution, prohibition on public sector collective bargaining. And we can talk about, we'll talk about that later on in terms of why some states have done that. In other states, it's a voluntary relationship. That is to say, local governments have the option to negotiate. In New York, it's required. So under the Taylor Law, all local government employers, all school districts, all state agencies, all public authorities are all required the same way to negotiate and follow the rules of the Taylor Law. So with that said, the state needed to set up its own structure, and it's very, very different from what the federal government had set up. I just want to throw this quote up here because it's always fun. All government employees should realize that the process of collective bargaining, as usually understood, cannot be transplanted into the public service. That is to say, we can't just copy and paste the National Labor Relations Act into state law because the dynamics are so different. For one thing, you're not adjudicating how much of the profits in a business should be shared with employees. The other thing is that the people negotiating on behalf of the taxpayers have the ability to always go out there and get more money to grant whatever is being demanded at the bargaining table. So we have these very different dynamics. And this guy who said it, it was not Governor Scott Walker of Wisconsin. I could give you a hint, but it would cost you 10 cents. Yes, it was this guy. It was Franklin Roosevelt. That was a letter he wrote to one of the public employee unions in the 1930s, explaining that the relationship between the federal government and them had to be very, very different from the relationships that businesses had with their unions. So, zooming in on New York, the first thing I want to mention here is that even before the state passed the Taylor Law in 1967, even before we created this process for negotiations, the state had already set the floor pretty high. That is to say, we had a civil service system. This is the merit and fitness system that began in the Progressive era. And by the 1950s, 1960s, it had been really substantially beefed out. Chief among them were due process protections. One of the biggest gets for private sector unions was protections against improper dismissal, due process in the disciplinary matters. And New York public employees already had this. New York public employees also had constitutionally protected pensions by the 1950s and 1960s. So things that the unions in the private sector had taken decades to get, New York unions already had when they were first sitting down at the table under the law. Now, another really big misconception that I want to clear up here is that somehow strikes were banned by the Taylor Law. Strikes have always been banned in New York. We've never allowed public employees to go on strikes under any circumstances. In 1947, there was a big strike by Buffalo teachers, and in response, the state enacted the Condon-Wadlin Act. And the Condon-Wadlin Act was a prohibition on strikes with penalties that would ultimately be seen almost as draconian. Essentially, they said anybody who was essentially the strikers were treated as fired as a practical matter, and they could only come back to work if they didn't get any financial benefit from having gone on strike. And because the penalties were as strict as they were, there was a reluctance to enforce the law. And all the while, you had a lot of labor unrest progressing in the 1950s and 1960s. This culminated in a series of really disruptive strikes in New York City. There were some big teacher strikes in 1960, 1962. There was a big transit strike in 1966. And this all comes to a head. This is happening statewide as well, in a lot of the school systems. And you get Governor Rockefeller convened something called the Taylor Commission under Professor George Taylor from Pennsylvania. And their job is essentially to try to transplant as much of the rules and procedures from the private sector over to the public sector in New York to create the processes by which unions could be recognized, negotiations could be conducted, and strikes could be prevented. The main goal of the Taylor Law when it was enacted was labor peace. It was bringing strikes under control. So here's Governor Rockefeller a year after the Taylor Commission was convened, signing it into law. One really interesting distinction I want to draw here is the law was enacted in 1967, and the legislature worked very hard in the 3-4 years afterwards, having annual investigations into how it was working. They looked at the numbers, they looked at the practical effects of the law. They did not fire and forget. That's a big distinction between what happens with New York state government today, where the legislature passes the law, the confetti falls from the sky, and that's the end of it. Here, they watched really, really closely. They made a lot of adjustments to the mechanical processes that the Taylor Law created. In terms of how they were dealing with strikes, because strikes did continue, how the Taylor Law was being interpreted. So the legislature really stayed on its A game for the first few years there. So the Taylor Law, let's talk about the nuts and bolts of it. Like I mentioned, unlike a lot of other states, it requires the employers both to recognize and to negotiate with public employees. And it sets a process for how they come to agreements, and essentially binds the government, binds the local government, binds the school district, binds the state to those agreements even after the next election. These contracts exist outside our normal democratic process. The Taylor Law, this was a change made later on, but it's important for our purposes here. The Taylor Law requires exclusive representation, which means if you have a group of employees who have been designated as being similarly situated, they have a community of interest, they're all in the same bargaining unit, everyone in there, regardless of whether or not in terms and conditions of employment in the contracts. And it means that the employer cannot deal directly with them on any subject that is reserved for essentially reserved for union negotiation. So anything that is a negotiable thing. That's something called direct dealing. People get in trouble for it from time to time. The Taylor Law created the Public Employment Relations Board. We'll talk about them in a minute. They've got their own slide here, but they are the most important state agency you have never heard of. The Taylor Law creates dispute resolution tracks. So when you have a union and an employer that can't reach an agreement, the Taylor Law first will get the mediation just to try to get both sides around the table. If that doesn't lead to an agreement, Herb will do fact finding. So they'll go and they'll look at similar employees in other local governments or other state agencies, or I'm sorry, other public authorities, They'll look at similar employees elsewhere, look at the ability to pay, look at the circumstances around the negotiation. So to try to bring the parties closer together to understand what's realistic in terms of what either side is asking for. And in some cases, then they can go to another round of mediation where they'll actually get a proposed settlement. They can decide whether they take that. In some cases, since 1974, the state has also created binding arbitration provisions where, particularly with police, with firefighters, transit employees, certain corrections officers, the state has said, because you aren't allowed to strike, we will create a system where you can where we can essentially split the baby between proposals and decide which side gets what, and then that'll be the binding settlement, so that we don't run into a situation where you're without a contract for years and it puts labor peace at risk. That's been the rationale between two of the biggest changes to the Taylor Law. One of them was the creation of binding arbitration in 74, and the other one was the creation of the Triborough Amendment in 1982, where essentially the argument was, because folks can't strike and it would be disruptive if they did, we're going to do things that essentially bypass the normal negotiation process. In the case of the Triborough Amendment, that is a provision of the law that keeps all provisions of a contract in place even after it has expired. And I've got a separate slide on this we'll come back to. So like I said, PERB, it's a three-member commission with a chairman picked by the governor. It is the most important state agency you have ever heard of. They enforce the Taylor Law. Their job is to prevent strikes. It's to adjudicate disputes on what is and is not subject to negotiation, and then to mediate disputes between the parties in order to preserve labor peace. They have about 32, 33 employees. This is one of the few state agencies that I would argue should be bigger and should have more manpower, because they also have a really important research mission. They're supposed to be looking at how the Taylor Law is working out. So not just looking to see how many strikes we have, but also looking and measuring what it is that all the contracts across the state are saying. There are more than 5,000 union contracts in force at any given time under the Taylor Law, and it would really benefit public employers, town supervisors, school superintendents, to have more of a global read of what all those contracts say, because in reality, more than half of those contracts are being negotiated by just two unions, NYSET and CSEA. And as a result of that, NYSET and CSEA have a really good, clear read on everything that's happening because they're negotiating so many of those contracts, whereas individual town supervisors, individual school superintendents don't necessarily have that. So PERB is supposed to be doing more than they are. Their budget really got squeezed in the Patterson era and the Cuomo era, but they have a very important research mission with respect to the Taylor Law, and I hope to see them get back to that more. So we have this framework that requires people to negotiate, but then there's the question of what are you supposed to negotiate over? These are called the subjects of bargaining, and they're split into three categories. There are mandatory subjects of bargaining, and these are the common sense things you'd say. These are, of course, these are things that need to be contractual, because if they weren't in the contract, it would defeat the whole purpose of doing this. So, for instance, anything pertaining to what you're paid or what your benefit level is as an employee, that's a mandatory subject of bargaining. Then there's a category of things called the non-mandatory subjects. These are things where management has a prerogative, but they have the option to go and negotiate over it. So for instance, the number of people working in a particular operation, a police department is a great example. That's a non-mandatory subject of bargaining. You don't have to put that in the contract. Now, once it is in the contract, it stays in, you'd have to get both parties to agree to take anything on that subject out of the contract. But once you put it into the if it's not in the contract yet, and you are to say, if you're a mayor and you say to your police officers, I don't have money for the level of raises that you want this year, but instead I can require that we have a minimum level of staffing, or that a minimum number of police officers are on duty at any given time. These are instances where management has the right to give away the management prerogative. And the tough thing is, once management gives away that prerogative, it doesn't reset at the next election. Like if you have a new mayor come in, looks at this contract and says like, "Oh, why'd you agree to that?" There is no snapback in that. Once it's in there, it's in there. And then finally, we've got a whole separate area of things called prohibited subjects. Pensions are the best example. Part of the reason why New York is not the debt-laden disaster that places like Illinois are is because retirement benefits can't be negotiated in the collective bargaining process. They get set by state statute, but they're not something that can come up at the table. And that's a really good thing. And we'll talk about this later. That's because of the way the incentives are structured at the negotiating table. So these have on the right, that's a screenshot from the Subjects of Bargaining. That's a book that's maintained by PERB, and it's over 100 pages long, and it goes back through 50 years of PERB adjudications where two sides came to PERB saying like one side wants to negotiate over something, the other side doesn't want to negotiate over something, and PERB has decided either that is mandatory, that is non-mandatory, or it is prohibited. In terms of the prohibited subjects, pensions are explicitly prohibited by state law, but also what they mean by prohibited subjects is anything that's preempted elsewhere in the state law, where the legislature has vested powers specifically in public employers, in the elected officials, and they can't give that away. So there was an example in the 70s where I think some teachers in Cohoes wanted to negotiate over which kids got assigned to their classes the next year, and PERB said no. This is something that this is a power that's reserved for school administrators. They can't just they can't give that away in the bargaining process. To talk about some of the hotter issues in subjects of bargaining today, number one, it's discipline. So like I said, we already had this really good due process system in the civil service law going back to 1958, before we started having collective bargaining under the Taylor Law. However, one remarkable thing about the Taylor Law is that it kind of says anything goes unless, like I said, unless it's bolted down somewhere else in the statute, things are negotiable. And one of the most consequential things that have been negotiated over the years are discipline rules. And the thing that unions always aim to go for with discipline rules is to have decisions about discipline moved away from the people's elected officials to independent arbitrators. And the incentive for that is independent arbitrators know that if they rule against unions in disciplinary disputes, they're not going to get hired anymore. So they have a financial incentive kind of to lean on the side of the arbitrators. It also makes the discipline process a lot more expensive and curbs mayors and school superintendents and town supervisors from seeking to do discipline in the first place. So I've got a screenshot here from the Marshall Project where they did this great job looking at New York State's attempts to terminate abusive prison guards. And they found that over 12 years, 3 out of 4 of the COs that they tried to fire for abuse or abuse-related charges ended up back on the job. And it was because of this arbitration process. Arbitration has been curbed for police officers in some cases. There was a landmark case in 2006 where the city of New York basically successfully argued that disciplinary power should be reserved for the police commissioners, that they couldn't be given away as they had been in previous administrations. So for New York City, for towns, for some of the downstate counties, it's really a patchwork, but police discipline has been reserved for the elected officials. It's become a prohibited subject of bargaining, but it still remains in the contracts in a lot of other places. So small cities, villages, these are things that the court's going to be working out for the next few years. Staffing levels get put into contracts, and staffing levels are a really sticky thing because staffing needs change. Technology changes, population changes. So for instance, you have upstate cities like Watertown, where the fire contract set a minimum level of staffing. And this was decades ago. And Watertown's population has fallen by but it's down by about a third from where it was at its peak. Also, fires are becoming, thank goodness, thanks to technology, fires are becoming less frequent. However, because the contract still requires a minimum level of staffing, the city has still had to go and spend the money on that minimum level of staffing, and they went to court over a couple of years trying to get that changed, and they found, and the courts were unwilling to change that. They said no, staffing levels are still permissible as subjects of negotiation. Finally, you have overtime rules. And one thing that we see labor try to do is get overtime assigned by seniority. Now, if anyone here who has dealt with government payroll knows that if you have to offer overtime first to your most senior people, you are by definition offering it to the most expensive people. This is part of the reason why overtime is so crazy at the MTA, because not only do they have to offer it to the most expensive people first, on the New York subway, the Long Island Railroad, Metro North, but these are often the most senior people who are often the closest to the retirement. So they have an incentive to go and try to get as much overtime as possible, and to spike their pensions. And all of this comes back to how the contracts have gotten into the overtime space instead of leaving it to employers to decide how it's assigned. So I mentioned the Triborough Amendment to the Taylor Law. The Taylor Law was enacted in 1967. There are, you have about a decade of people negotiating under the Taylor Law. You've got disputes over the Taylor Law. One thing about contracts is they expire. So one of the things that there was litigation over in the years in the 1970s was what happens when we have negotiated on a non-mandatory subject of bargaining and the contract expires. The courts had held, you can't cut someone's pay to minimum wage just because their contract has expired. You can't take away their health insurance. That had all been clarified by the court. That was called the Triborough Doctrine. What the courts did say was if you have promised raises in future years and the contract expires, you don't have to give those raises. And the courts had sided with employers on holding back on those raises when contracts had expired. And in 1982, the legislature, this was something driven by the Senate Republicans, the legislature enacted a change to the Taylor Law saying all terms and conditions of employment shall remain in force until a subsequent agreement has been enacted. The place where this has the biggest impact is on raises, not just in guaranteeing those raises, but because it creates an incentive for unions to hold off on negotiating, because as long as their members are continuing to get raises, particularly seniority-based raises, particularly with teachers. I've got an example here from the Buffalo City school contract where you can see teachers get paid on 25 different experience-based steps, and teachers continue up those steps even when there isn't a contract in place. That was the case in Buffalo between 2004 and 2016. Buffalo teachers went 11 years without a contract. One of the big sticking points was that they did not want to give up their free elective cosmetic surgery benefit, which was costing the city $5 million per year. But they continued getting raises. They continued getting raises through that entire time. In most cases, unless people had hit the very, very top of the pay scale. And that's what made it so hard for the teachers union and the city to reach an agreement, because there was still that, under normal circumstances, 11 years without a raise, you'd have a lot of pressure to sit down and work out a deal. But that was absent, and that's because of the Triborough Amendment. And I mentioned the raises as one thing, but just generally speaking, whenever you're keeping the parties away from the table, you're keeping them from addressing the nuts and bolts of the contracts that have to do with how government is responding to changing conditions, how they are adjusting all those other subjects of bargaining. Some teachers union contracts are over 100 pages long. They can control the exact hours of operation for the school day, how personnel are assigned, the disciplinary provisions, all sorts of things that do need constant adjustment to respond to changing circumstances. And with Triborough there, and then also with binding arbitration, you're keeping people away from the table, and you're not you are essentially putting a lot of policy decisions in cement, basically, because they become so hard to change. So, as a practical effect, first and foremost, people sometimes get the idea, well, public employees unionizing leads to higher costs because we have to pay them more. Like, yes, people do negotiate for higher pay when they unionize, but that's not the whole picture. You get higher costs from public sector collective bargaining because you take away the flexibility of management. Like I said, you can have things like mandatory staffing levels. You can have things like obstacles to discipline that require you to keep underperforming employees on the job who otherwise wouldn't be there. Management gets their hands tied. Management has to pay out more for overtime than they otherwise would. These are all things attributable to the Taylor Law. Personally, probably my biggest criticism of the Taylor Law isn't the financial component to it all, because it's spending is a policy preference that the people can express through their election of their democratically elected officials. It's policymaking outside the normal democratic process. That is to say, you have decisions about public policy being made behind closed doors, and they're being made by elected officials who have an incentive to first off, to get short-term wins for themselves without a great interest in the long-term effects. That's why we're so lucky in New York that pensions aren't negotiable, because it would be easy for somebody to sit down at the bargaining table and promise someone 50% extra pension in retirement when it's a cost that they're not going to have to really incur in the short term. Probably the worst example of this happened in Utica, maybe I want to say about 15 years ago. The school superintendent sat down and promised retirees, perpetual health care promised employees perpetual health care in retirement as part of the contract process. The immediate fiscal impacts were almost zero. I mean, it was so small, but it ultimately was, it was millions and millions of dollars of liabilities that the superintendent put on the books there. And this was something that was done, again, outside the democratic process, and people didn't know about it, in some cases, until after the school board had already ratified the contract. So it is not a way that we are accustomed to making decisions in a democracy, and it's something where a lot of the worst contract provisions go back to these rushed and opaque negotiations that where the public did not become aware of it until after they were bound to the terms. So just looking at the Taylor Law today, there are more than 5,400 bargaining units in place. Nearly every school teacher, police officer, paid firefighter, transit employee is unionized. We see some mid-management getting unionized, like vice principals, supervisors in the MTA. It goes so far as to the state's gone so far as to allow some really unconventional groups to unionize. For instance, grad students at SUNY, childcare providers who get state stipends, they are covered by the Taylor Law. It's really, the state has kind of strayed afar from the whole question of preserving labor peace, and in some cases kind of treated unionization as an unalloyed good that should be promoted for its own sake. We are near zero in terms of strikes. Strikes are really rare. They're happening on an average rate of less than one per year. One of the last ones was 2018, 2019. It was in Buffalo, where there was, the union argues that there was some kind of safety situation, and a few dozen staff called out sick because of a safety situation at a school. But these are pretty rare cases. The last really big strike in New York was 2005 with the subway strike, December 2005. Prior to that, the last big teacher strike was in 2000 in Yonkers. So the Taylor Law has a good record in terms of reducing the incentives to strike. You could argue, however, that given the extent to which it's taken away decision-making powers from the people's elected official and driven up costs, the state's probably gone too far and needs to look to other states and probably dial back a little bit in its approach. One notable thing about the Taylor Law is that it covers all public employees uniformly. Looking at a lot of other states, they'll treat their uniformed police and fire separately. They'll treat their teachers separately, and they will tweak the laws accordingly based on what the policy needs are there. The Taylor Law is a one-size-fits-all thing. Another interesting thing with respect to the Taylor Law was in 1977, the Taylor Law was amended to require all public employees who were covered by a union contract to pay the union. It was called agency shop. This was something that continued until 2018 in the Janus decision, where employees no longer had to pay. We found in New York State government about 15% of people stopped paying. That number is continuing to decline when they were no longer compelled to pay. One thing it did do, that period of time of requiring people to pay did give people an incentive to join the unions because they were going to have to pay the unions one way or the other. In this chart here, I want to draw a distinction. One interesting thing about how unionized the public sector is. Roughly today, about 68% of people working in the public sector are covered by a union contract. A small share of these people are federal employees, but it just goes to show you just how far-reaching the Taylor Law has been in the public sector in New York. And you compare that to the extent to which the National Labor Relations Act affects New York's private sector employees, where we only have about 12% unionization in the private sector. So you have a lot more of the private sector kind of operating on a more flexible basis than you do the public sector. Finally, I want to offer up a couple resources here where you have, these are a couple reports that the Empire Center did, tailor-made. That's Terry O'Neill and E.J. McMahon's terrific 2018 report looking at the history and the practical impact of the Taylor Law. EJ did a great report in 2012 called Triborough Trouble, which talks specifically about how Triborough was providing a disincentive for unions to negotiate on stuff and what the ramifications of that were. We also have See Through New York, where we collect. We have the single biggest collection of public employee contracts. The state is supposed to collect them. The state does not collect them. We collect them through the FOIL process. We digitize them. We upload them. They're searchable. So if you are going into negotiations and you need to know basically what the comparables are, what the other public employers are that you're going to be compared to, you can go in there and you can get their contracts and make comparisons. And finally, just one really quick editorial. The Taylor Law is a super interesting, super specialized field where, that is where you can often, it is not something that every lawyer can do well. So if you're a public employer, if you're an elected official and you're dealing with Taylor Law matters, it often behooves you to, you get what you pay for. It often behooves you to go out and get some of these more specialized Taylor Law pros who do it, who do it day and night. And I'm not singling anyone out here on this call, but I've been lucky enough to work with the real pros of the Taylor Law who know the stuff inside and out. So with that, I'm happy to take any questions you have here.